India Legal presents Court This Week.
Hello and welcome to the Courts This Week. I am Pragya. In this special edition, we will bring you top stories from legal proceedings from various courts. Now, from the lower and subordinate to the high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines in the week. In the next half an hour, we will inform you and update you on all the important proceedings that have taken place. So let's start Courts This Week.
India Legal presents Court This Week.
Now, in some news related to loan moratoriums, the Supreme Court has given the RBI, the centre and the banks a week's time to file their replies and observations on the issue of loan moratorium and interest payment for sectors that have claimed they deserve repayment consideration because of the COVID-19 pandemic. The court will hear the issues again on October 13th.
The Supreme Court has granted a week's time to the central government, the RBI, the Indian Banks Association and the individual banks to file an additional affidavit bringing on record the policy decisions, deadlines, circulars and response on all grievances raised. The bench headed by Justice Ashok Bhushan noted the submissions of the writ petitioners that October 2 affidavit of the government does not deal with several issues. Although in its paragraph 18 the affidavit announces the decision of the government to waive off compound interest on loans up to 2 crores of rupees in respect of 8 categories of borrowers, no consequential notification or circulars issued by the central government or the RBI to implement the same have been brought on record. A bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah was hearing the petition seeking waiver of accruing interest during the 6-month loan moratorium period. The centre in its affidavit filed last week before the Supreme Court has agreed to waive off compounded interest for loans up to Rs 2 crore during the 6-month loan moratorium period. In its affidavit, the government has said that the relief on waiver of compound interest will be for MSME loans, education loans, housing loans, consumer durable loans, credit card loans, auto loans, personal loans, consumption loans, all up to Rs 2 crore. Counsel for CREDAI submitted before the court that there were a lot of facts and figures present in government affidavit which were without any basis. CREDAI disputes the Rs 6 lakh crore mentioned in the government in its affidavit and asked for a few days to reply to the centre's affidavit. In the submission, the CREDAI also reminded the court that it has to pay full interest from September 1. Senior advocate Aryama Sundaram, arguing for CREDAI, said that there has been no relief package announced by the centre for the real estate sector. There has been neither any loan restructuring proposal or plan given to this sector by the centre, he said. Solicitor General Tushar Mehta replied that sector-wise relief was given in view of available resources. At that, the bench asked the centre to give details on how banks would proceed with this plan. Senior advocate V. Giri, arguing for the RBI, said that the decision had been taken at the highest level to handhold small borrowers. Mehta said that the mechanism proposed has to be put in place by the banks. The petitioners have sought an extension of loan moratorium period. At that, the Council for the Banks Association presented its problem. He said that accounting has frozen after the Supreme Court stopped us from classifying account as NPAs. We need few days to reply to government's proposal. At that time, the Solicitor General Tushar Mehta reminded the court that the RBI's dialogue with the centre and the stakeholders was subject matter of judicial review. The bench considered requiring the RBI and the central government to file affidavits by Friday so that the rejoinder, if any, is submitted by Monday. The matter will now be heard on October 13th. Bureau Report.
Now, as Shaheen Bagh protest case reached the doors of the Apex Court, the right to protest in public places is not absolute and public places cannot be occupied indefinitely for such protests. The Supreme Court ruled on in a case highlighting the troubles faced by general public due to the road blockade at Shaheen Bagh in South Delhi by protesters who were opposing the Citizenship Amendment Act. It said dissent and democracy go hand in hand, but protests must be carried out in designated areas. A three-judge bench headed by Justice Sanjay Kishan Kaul ruled.
Protesters cannot occupy public places indefinitely, the Supreme Court said this morning in a hugely influential verdict on a batch of petitions against the protest that swept Delhi Shaheen Bagh against the contentious citizenship law cleared the parliament last year. Dissent and democracy go hand in hand, the top court observed, stressing that protests like this are not acceptable. We have to make it clear the public places cannot be occupied indefinitely, whether in Shaheen Bagh in Delhi or elsewhere. This sort of protests are not acceptable and authorities should act. They must keep such spaces free from obstruction, the top court said, adding the administration cannot wait for orders from the court to clear the protest site. We appreciate the right to peacefully protest and it can be held at designated places only, the court stressed. A three-judge bench of Justice S.K. Kaul, Aniruddha Bose and Krishna Murari announced the judgment while hearing a clutch of petition to decide if there can be an indefinite period of protest in a common area creates inconvenience for others. The bench had reserved its verdict at the last hearing on September 21st. We have to balance the right to protest and blocking of roads. In a parliamentary democracy, protest can happen in parliament and on roads, but on roads it has to be peaceful, the bench had said at the time. The court had earlier noted that there cannot be a universal policy since circumstances may vary from case to case. Delhi Shaheen Bagh had emerged as the epicenter of anti-CAA protests last year, where the protesters, mostly women and children, sat for more than 3 months. The Shaheen Bagh protest received worldwide attention, and the Time magazine honored 82-year-old Bilkish Dadi, the face of the movement, as one of the 100 most influential people of 2020. Critics have said the contentious citizenship law, which the government says enables citizenship for non-Muslims from Pakistan, Bangladesh and Afghanistan if they escape religious persecution and enter India before 2015, is anti-Muslim. A massive wave of protest has swept the nation against the CAA before the novel coronavirus pandemic forced a majority of population indoors and the government announced one of the world's strictest lockdown in March. Bureau Report.
Now, in the long-going Sushant Singh Rajput suicide case, actor Riya Chakrabarti has been granted bail with conditions nearly a month after her arrest over drugs-related charges in the Sushant Singh Rajput case. Her brother Shawik, however, has been denied any reprieve by the High Court in Bombay. Another court had yesterday extended their judicial custody till October 20th. Sushant Singh Rajput's employees Dipesh Sawant and Samuel Miranda have also been granted bail. Here's a report.
Riya Chakrabarti has been asked to submit 1 lakh rupees as bond and mark her presence daily at the nearest police station for 10 days after her conditional release. She also has to hand over her passport and cannot travel abroad without the court permission. Reacting to the bail given to Riya, her lawyer Satish Manisande said, "We are delighted by the order. Truth and justice have prevailed and ultimately the submission of facts and law have been accepted." Riya Chakrabarti was arrested on September 8 by the Narcotics Control Bureau on charges of organizing drugs for Sushant Singh Rajput, a popular movie star who was found dead in his Mumbai apartment on June 14. She was accused of being an active member of drug syndicate and financing drugs used by Sushant Singh Rajput, her boyfriend. In her bail petition, Riya Chakrabarti has said that she and her brother were sole targets of witch hunt by multiple agencies who had found no evidence incriminating her in the case. She had alleged that Sushant Singh Rajput took advantage of those closest to him to sustain his drug habit, and that she had tried to rid him of it. She also said that she was diagnosed with bipolar disorder and his family abandoned him at the peak of his depression. His mental health deteriorated during the lockdown, she claimed, adding that the death of actor Irfan Khan and Rishi Kapoor also had a tremendous impact on him. Sushant Singh Rajput was extremely happy after being offered 14,000 crore rupees for a movie, Riya Chakrabarti bail plea said, alleging that the actor was disturbed over a rift with his family, especially his father. Riya Chakrabarti also argued that the charges against her were too severe compared to the quantity of drugs involved. She accused the Drugs Probe Agency of spinning a false narrative that she was involved in illegal drugs trafficking and harbored offenders. The CBI is investigating the circumstances of Sushant Singh Rajput's death, and the Enforcement Directorate is looking into financial allegation raised by the actor's father. The Narcotics Control Bureau stepped into the Sushant Singh Rajput investigation when WhatsApp chats retrieved from Riya Chakrabarti's phone revealed alleged conversation involving the procuring of drugs. Several top actors have been questioned by the Anti-Drug Bureau in the widening probe into drugs and the film industry. Bureau Report.
Now, the Allahabad High Court has reserved its order in a plea connected with Hathras case. A habeas corpus plea on the behalf of victims' family was filed in Allahabad High Court accusing the district administration of illegally confining them in their house. In another development, the main accused in the case has written to the Uttar Pradesh police claiming that he and the three other accused are being framed in the case and sought justice for the four men.
A petition filed by the Akhil Bharatiya Valmiki Mahapanchayat on behalf of victims' family in Hathras has said that the victims' parents, two brothers and two other relatives have been prevented from meeting or communicating with people freely, thereby violating their right to freedom of speech and expression. In the petition filed in the Allahabad High Court, the family has alleged that they were detained in their house by the district administration on 29 September and 30th September and were not allowed to meet anyone. While later they were allowed to meet a few people, they have not been allowed to move out of their house at free will. The habeas corpus plea has sought the release of the petitioner from illegal confinement. Meanwhile, the main accused in the case has written to the Uttar Pradesh police claiming that he and the three other accused are being framed in the case and sought justice for the four men. He also accused the woman's mother and brother for torturing her. The letter has emerged amid police claims that there is evidence that the victim's family knew one of the accused. Sandeep Thakur, who is in jail along with the three others, has written a letter to the police in Hathras claiming that he and the 20-year-old woman were friends. Apart from meeting, we used to speak on the phone once in a while, he wrote on Wednesday in the handwritten letter in Hindi. The letter has the thumb impression of all the four accused. The UP police had claimed that call records revealed that the woman's brother was in touch with Sandeep Thakur. Some 104 calls were made between the brother and Sandeep Thakur from October last year to March, the police claim. Sandeep Thakur in his letter alleged that family did not like their friendship. On the day of the incident, I had gone to meet her in the fields that day where mother and brothers were also present. I returned home after being asked by her to do so. Then I started feeding cattle, he said. I later got to know from the villagers that her mother and brothers beat her up over our friendship, injuring her badly. I have never beaten her or done anything wrong with her. Her mother and brothers falsely accused me and three others and sent us to jail. We are all innocent. Request you to please investigate and get us justice. he said. However, victim's father has denied the allegation made by the accused. The allegations are totally false. We don't need and want any compensation or any money. We want justice, he said. Bureau Report.
The Supreme Court has set aside the Allahabad High Court order which had allowed former Union Minister and BJP leader Chinmayanand to seek a certified copy of the statement of the victim recovered under Section 164 of the Code of Criminal Procedure. A bench headed by Justice UU Lalit dictated the order and stated that the appeal filed by the law student was allowed, thereby overruling the November 7th order of the court, which had allowed Chinmayanand's application seeking a certified copy of the statement of the victim recovered under Section 164 of the Code of Criminal Procedure.
In the rape case files against him, the Supreme Court has refused to grant former BJP MP Chinmayanand access to the complainant law student's statement to the magistrate under Section 164 of the Code of Criminal Procedure. The court has thus set aside the Allahabad High Court order directing that Chinmayanand be provided a copy of the statement made by the Shahjahanpur law student. In November last year, the court had granted an interim stay on the Allahabad High Court's order allowing former Union Minister Swami Chinmayanand to access a certified copy of the statement recorded by the Shahjahanpur law student who had levelled allegations of sexual harassment and rape against him. The complainant had argued that the High Court's direction granting Chinmayanand access to a copy of her statement before the filing of the charge sheet was contrary to law and may have far-reaching effects. The precondition for obtaining the copy of statement of the victim under Section 164 CRPC is that the charge sheet has been filed and cognizance has been taken by the magistrate. Section 207 and 208 of CRPC, which contemplates supply of copy of police reports, statement and documents and other documents to be accused, envisage the same. The petitioner had further submitted that the High Court's reliance on the judgment rendered in Raju vs. State of UP and others was flawed in as much as the same was a reference to an approach that was adopted prior to the amendment of CRPC in 1973 and that the criminal jurisprudence has seen an overhaul since then. The bench of Justices UU Lalit, Vinit Saran and Ravindra Bhatt stated that as per the terms of its previous judgment in 2014, a rape victim statement should preferably be recorded within 24 hours directly before a lady magistrate. The Supreme Court had previously directed the Uttar Pradesh government to set up a special investigation team headed by an IG rank officer to look into the charges levelled by the woman who had gone missing after accusing Chinmayanand of harassment. On 21 September 2019, Chinmayanand was arrested by the SIT and sent to jail. The 23-year-old student was also booked on charges of extortion. In February this year, the Allahabad High Court granted bail to Chinmayanand, finding that it is unclear as to who has used whom between the former BJP MP and the LLM student who has alleged the sexual assault. In March, the Supreme Court dismissed the petition challenging the bail granted to Chinmayanand by the High Court. The court also issued notice to Chinmayanand in a separate plea seeking transfer of the trial in the rape case against the former Union Minister from the Uttar Pradesh to Delhi. Bureau Report.
And that's all for the Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.